Good afternoon, muted.
And welcome to the ALCTS webinar on Cases and Commentaries, Intellectual Property Issues for Librarians. I'm Kristen Martin, a member of the ALCTS Continuing Education Committee. Our presenter today is Anne Gilliland. Anne is a lawyer and a librarian with an MS in Library and Information Science from the University of Tennessee and a JD from Capital University Law School. She is the head of the Health Sciences Copyright Management Office at The Ohio State University. If you have a question for Anne, please type it into the question box on your screen, and Anne will do her best to answer them through a couple of predetermined times in the presentation and then at the end. Also, please note the session will be recorded, and you'll receive an email shortly after the conclusion of the webinar that has a link to the recording. And you'll also receive a copy of Anne's slides. So I'm going to turn it over to Anne, and there may be a slight delay as I do this.
Hi, this is Anne Gilliland, and I'm really happy to be here today to talk to you about some current issues in copyright and intellectual property law. And I see from the attendees list that there are some people in the audience who know, I think, quite a bit about this subject too. So during the breaks for questions, if you have comments or things to add about the presentation, feel free to do so. I think it's really helpful to have all of us participate to the extent we can in this format. I'll start today by just giving you the standard sort of disclaimer. This presentation isn't legal advice. I'm not your lawyer. If you need a lawyer for some issue that you're dealing with, you should look elsewhere. This presentation is intended to be information and education only. So first of all, a little bit about me. I have a background in technical services and systems, and I worked as a librarian for many years, both here in Ohio and also in Tennessee. Most notably, I worked at the Ohio Library and Information Network for 15 years, and for most of that time I was essentially their technical services department. I worked with a lot of issues involving the central catalog for the Ohio State system, and for issues involving sort of acquisitions kinds of things, serials issues, and so forth like that. In midlife, I decided that I'd like to go to law school, and so I started law school in 2004. And during that time, I continued to work at OhioLink, and I realized that I was really interested in copyright law. I'd first gotten a sense of that when I was still at OhioLink and was asked to do a presentation about serials aggregators, and I was assigned to do the so-called boring parts about the Ticini litigation, and I thought it was really interesting. So interesting, and I began to think, maybe I could do this. Maybe I could go to law school and learn more about these sorts of things. So why does intellectual property issues, why do they matter to libraries? We librarians and libraries operate to a large extent within the exceptions in the copyright law. These include something called Section 108, which involves the reproduction exceptions for libraries, for interlibrary loan, for safe harbors for liability when patrons photocopy, and also for the first sale doctrine. That's a huge part of why libraries can even exist. This is the doctrine that allows us to lend the books that we buy and lend the other materials that we buy. And we also make heavy use of the exceptions for fair use. All of these things mean that copyright and intellectual property are really at the heart of our operations and at the heart of what we do. We're also, as you all know, hugely a part of the business of content dissemination and production. They have a bearing on what we do. We store content, we use content, and increasingly we also create content. So libraries throughout the years have gotten caught up in various legal cases and controversies that involve intellectual property and copyright, sometimes as interested bystanders and sometimes as defendants. Sometimes, in fact, the case isn't particularly about libraries, but the issues at stake have a bearing on the work that we do. Some examples of that where we have been interested bystanders was the Ticini litigation I just mentioned, where the issue was the freelancer's copyright within the scope of aggregating databases. Another recent example has been the Costco v. Omega situation, which involved the doctrine of first sale. In some cases, libraries and library organizations have been the people who or entities that file amicus briefs, friend of the court briefs. We have an interest in this work even though we're not one of the parties. In other cases, we have been defendants in lawsuits, such as the Williams and Wilkins case in the 1970s, and today the Georgia State litigation. There are a lot of economic interests at stake in the process of copyright litigation and controversies, and although we think of ourselves many times as not-for-profit organizations that really aren't about money, we are not immune from those economic interests, and so not immune from those controversies either. One of the things that our library associations do for us is that they take stock of the situation with regard to intellectual property in libraries, and there is an organization called the Library Copyright Alliance, which monitors copyright activities, monitors cases, monitors situations, and acts for the member organizations when necessary. The LCA is made up of ACRL, ALA, and ARL, the Association for Research Libraries, the American Library Association, and the Association of College and Research Libraries. The Library Copyright Alliance files briefs in support of issues in cases where there perhaps is no library party to a lawsuit, but where there is an interest on the library's part. This is also a way for libraries to get issues on the table at the appellate level of litigation so that they can be part of the national conversation about intellectual property. It's a way for libraries to be a part of that mix that's going on all the time right now involving culture and intellectual property. And even if you don't agree with every issue and every position that the LCA takes, I would argue that it is very important for us to be in the conversation, and the Library Copyright Alliance makes this possible. These are discussions of scholarship, of culture, and we need to have a voice there. They affect all types of libraries, especially academic libraries, but also other types of libraries as well. And it's really wonderful that we have organizations that spend some time monitoring this. So first of all, I thought we would do a small poll to discuss how much copyright knowledge you feel like you're coming to this with. So just a moment, I will launch the poll and you will see it. So do you feel proficient and well informed about copyright, know a few things about copyright, or I'm just beginning to learn about copyright? I actually sometimes, often, almost always feel I know a few things about copyright. It's an extraordinarily rich and detailed subject, and there's always more to learn, I think. So I think you can see that most of you feel that you know a few things about copyright, and as I just said, I often feel that I'm just starting out too and learning. There's so much to learn about copyright, and particularly in the digital age, copyright has gotten a lot more complicated, and for people who have been involved in the field for many years, a lot more interesting too, because it's so much easier these days for everyone to reproduce and distribute all kinds of content. So today I'm going to talk about some current cases and controversies in intellectual property that have a bearing for libraries. And those cases and controversies, first of all, is the Georgia State litigation. I'm going to make a few remarks about the UCLA litigation, then talk about a case that's going to the Supreme Court called Golan v. Holder, say a few things about pre-1972 sound recordings and copyright, comment a bit on the Google book search litigation, recent statements and suggestions about copyright reform, and then say a few things about a case that was about first sale, although it's also about watches, called Costco v. Omega, and then wind up by talking a little bit about the copyright fair use best practices project that's in effect right now. There's a lot going on in the world of copyright right now, and as I made this list, which seems so long, there are even more things too that are of interest, but of course, you know, time is what it is. So the first thing I'm going to talk about is the litigation that's called Cambridge v. Patton. Most people call this the Georgia State litigation. And this is a situation that developed about 3 years ago at Georgia State with regard to electronic reserves. So Georgia State had a, I think, relatively liberal reserves copyright policy, and they also had what apparently was a security hole in their course management system. A group of publishers, Cambridge University Press, Oxford University Press, and Sage, sued Georgia State for copyright infringement over this situation, and alleged that Georgia State had digitized too much without permission and had made it available to the world. Georgia State tightened up their policy on copyright and e-reserves. They also closed their security hole, but the litigation went on, and the plaintiffs asked for, continued to ask for an injunction for Georgia State to cease their activities. At this point, I'm going to stop for a minute and talk about a couple of definitions, and one of them is sovereign immunity, which is a huge issue in this case, and the other is exactly what an injunction is. So probably some of you guys know all this already, but maybe some of you don't as well. So sovereign immunity is the doctrine that the federal government and the states cannot be sued. Now there are many, many exceptions to sovereign immunity, and there are also cases where the federal government or the states waive their sovereign immunity. One of the exceptions is for an injunction in certain situations, and this case was one of those situations where the suit is brought in the against the official capacities of the defenders, and there is no request for monetary damages. An injunction is a request for the plaintiffs to change their behavior. They aren't asked to pay any money. The plaintiffs say, we just want them to stop doing the bad thing they're doing or start doing the good thing they should be doing instead. In many cases, it's hard to get an injunction. Courts are reluctant to tell people what to do. It's easier to throw money at a problem. But in this case, there is a sort of maybe a loophole for a state defendant to be sued for an injunction, and the plaintiffs are taking advantage of that loophole. The other issue has been, so if Georgia State has stopped doing some of the things they used to do, has changed their copyright policy, for example, what's left to sue for? Maybe Georgia State has made the changes that the plaintiffs want, but the plaintiffs say no, that they want further changes in Georgia State's behavior, And the judges ruled that this case is going forward on the basis of Georgia State's present behavior, not the things it did in the past. But the plaintiffs still allege that Georgia State's conduct is infringing. They have alleged that that there is contributory infringement by Georgia State University. So Georgia State has declared that they won't settle the case, and so far they haven't since litigation began 3 years ago. The trial began 9 days ago on May 16th, so it's being held right now. The plaintiffs need to prove that there was an ongoing and continuous misuse of fair use. Was the e-reserves policy implemented in a way that meant that fair use was misused? So the question is the policy being followed? How is that working out? Did Georgia State know or have reason to know of infringement? Did they benefit financially? My understanding is that the trial is going to go sort of piece by piece through various e-reserves digitizations that took place and see what the outcome is in a very, very detailed and thorough manner. One of the things that's come out as people have been talking and writing and filing pretrial motions about the litigation is that the Copyright Clearance Center has a role in the litigation and it is financing 50% of the plaintiff's costs. And this has caused some, I'd say, bad feeling in the library community towards the Copyright Clearance Center in some instances. Another thing that has recently come out is when a plaintiff asks for an injunction, shortly before trial begins, normally the plaintiff is asked to provide a model of what he or she or they would like the injunction to look like should they win it. And what the publishers have said that they want is a very unusual change of behavior on Georgia State's part. They're asking for Georgia State to only copy very, very brief portions of library materials. They're asking for very great oversight of the university's behavior in this matter, and they're asking for very stringent limits on reuse across classes to an extent that is a little bit unusual. Many of their requests are based on some guidelines that were promulgated in 1976, so before people were using the internet and had as many ways to copy as they do now. The guidelines were supposed to be a floor to use, not a ceiling, and it isn't. They never have had the force of law, and they were not necessarily agreed to across the whole entire library community. So the guidelines are out there, that some people are using them, but no one has ever said this is what this constitutes the be-all and end-all of fair use. It's important to also remember that although the plaintiffs have asked for very stringent guidelines, they won't necessarily get them even if they do win. Of course, one asks for the maximum and may take what one gets. So with regard to Georgia State, what's the worst case scenario? If Georgia State loses their lawsuit, I think everyone involved in higher education librarianship is going to be watching very closely and thinking about what their behavior might need to be in light of it. It could be that much more extensive copyright permissions will be needed on campuses and that they would apply far beyond e-reserves only. The plaintiffs have asked for oversight of all kinds of behavior around use of copyrighted material by students and faculty. And one of the questions in all of this is that sort of oversight at all palatable to students and faculty? And I think most of us would say probably it is not. where do we go, however, if that's where we end up? It appears that very little would be fair use in the academic library world at that point. I think there are two sort of ways this could play out if Georgia State lost. One is that we might move to a very extensive permissions culture where we need to get permission to do a lot of the things we do with copyrighted material on campus. The other is that we might start to move to a more of an open access culture where we are using and encouraging the use of material that is freely available and either outside of copyright or has very permissive licenses that don't involve more costs. Either one of those are possible, and of course it is also possible that Georgia State will win the lawsuit too. So now we have the first break for questions, and I was wondering if there are any out there. I do not see any. None yet.
Yeah, at this point, we don't have any questions.
Okay.
So I think
so far
so good. Yeah.
Okay.
So let's carry on.
All right, we'll keep going. We're on schedule. So another piece of litigation or potential litigation that's been hanging out there a while in any amicus briefs filed. I've just got a question. Can you say more about amicus briefs? Who is supporting? Sorry, I got to look at my questions. I'm getting the questions now. Just a second. Who is supporting Georgia State? The Library Copyright Alliance has filed, of course, amicus briefs in this case, and other cultural and library groups too. They are the only defendant. Georgia State and some people who work there are the only defendants, however, in the case. Sorry, when I do whatever I did, there we go. Okay. That was me muttering about the webinar procedure. So back to UCLA. So UCLA streaming video litigation has been hanging out there for a while, something that was possibly going to be happening soon. What happened was that a distributor of Ambrose Films first threatened extensively and then eventually filed a lawsuit against UCLA, alleging that their use of streaming of DVDs violated copyright law and was a breach of contract. They actually went so far as to file the lawsuit relatively recently after much posturing on both sides. There are many procedural issues in this case. Some of them involve the way the complaint was written. There are a number of breach of contract issues that are related to copyright but not exactly copyright issues. And recently, the judge in the case is saying that she is tentatively planning to dismiss the lawsuit mainly on technical grounds, that the way the lawsuit was crafted was not really one that alleged causes of action that could go forward. So it looks highly likely that this lawsuit will be dismissed, which is good for UCLA and doesn't settle any points of copyright law in regard to this, but on the other hand, I think this was probably not the lawsuit that could go forward and make any of those things settled. There's also an interesting lawsuit that has just been granted cert by the Supreme Court, which means the Supreme Court has agreed to hear the case, and this is a suit called Golan v. Holder. So this suit involves the restoration of copyrights. And the issue is, can copyright be restored in foreign works once they have passed into the public domain? So what happened was that there were some copyrighted works where the copyright had lapsed, not because they were too old to be in copyright anymore, but because something else technically went wrong. For example, back in when a work had to be registered, it wasn't registered properly, or something else like that that was a relatively arcane matter took place. So there were a number of foreign works in this category, and as part of some issues involving an international treaty, Congress decided to restore the copyrights to these works. And of course, in some cases, people had started making use of those works thinking that they were in the public domain, because they used to be. So for example, people who perform various symphonies or other creative works had been using works that were not once in the public domain, and wow, now they're not anymore, and they've got to pay royalties. Educators were having some difficulties. People who restore film and distribute it had done some work to distribute some of these films, and now, lo and behold, they're in copyright again. And educators who are digitizing material have had a heck of a time with this situation, because it's become very, very difficult with foreign works to tell whether it's in the public domain or not in many cases. Some of this involves whether or when it was also published in the United States. The situations are very, very complicated, and they've just become a real sort of logistical nightmare. So the plaintiffs in this suit were people who made their livelihood from works that had been in the public domain and then left the public domain. For this kind of suit, they needed people who had economically relied on the works being in the public domain. And the named plaintiff the lead plaintiff in this case is a violinist and conductor who was conducting some foreign works that were in this copyright status. When the works copyrights were restored, people who were what they called reliance parties got to continue and use the works, but they did have to pay in order to do that. And in the lawsuit, the plaintiffs said that their First Amendment rights had been violated here. They had the right to, in a way, use these works as part of their expression, and then that was shut down. At appeal in the lower courts, the court held that the U.S. had to comply with this international treaty in order to get similar concessions from other foreign country partners, and that there really wasn't a First Amendment problem here. This was a reasonable thing for Congress to have done. But the plaintiffs had appealed to the Supreme Court, and the Supreme Court recently agreed to consider the suit. So what does this mean to libraries? I think it's something that is of huge concern to people who are digitizing. So if you're involved in digitization projects and you've got older material that was published in foreign countries, you probably know that it's really very difficult to sort of figure out what to do with that kind of material from a copyrighted point of view. It also is an issue for many of us wondering, could more material that is now in the public domain somehow leave the public domain too? One of the things the Supreme Court's going to be looking at is, as they say, did this law alter the traditional contours of copyright? This sort of restoration thing is not normal in copyright law, is the argument, and so have we sort of gone too far with kind of flexing the boundaries of what the public domain is and isn't when we do this? It's not the first time we flexed the boundaries. In several years ago, the Copyright Terms Extension Act extended the term of protection for a number of works, and the Supreme Court held that was constitutional. No problem here. The question is restoration of this sort different And the answer, I think, has a great deal of bearing on the digitization projects that more and more of us are doing all the time now. Another older situation that is kind of interesting and is very relevant in the world of digitization is the situation with the pre-1972 sound recordings. And I really like this picture because this record is just, you know, the quintessential late 60s, early 70s vinyl record, isn't it? Pre-1972 sound recordings aren't covered by federal copyright law. They're covered by what the Copyright Office calls a patchwork of various state laws. And consequently, it's hard to clear rights for digitization. It's hard to know what's in copyright. It's hard to know what isn't. It's hard to know how things got into copyright at this point, and whether the copyright's still good, and what are your choice of laws with regard to that. So the Copyright Office has been considering covering these pre-1972 sound recordings in the current copyright law. And right now they are taking comments on the issue. There's a conference on this issue in early June in Washington. And an example of the sort of situation we are in with regard to digitization and to some extent preservation of these recordings is seen in the National Jukebox Project of the Library of Congress. This is a relatively new project that they've started where they are streaming video of older and in many cases rare sound recordings, but the rights are held by record companies, and we can only stream. And the rights are not easy at all to clear in this situation. Some library groups actually oppose moving pre-72 sound recordings to federal copyright law, arguing that probably what would happen with a law that covered those recordings would be worse than what we have now. And there's some dissension or argument in the library community about whether the current sort of unsettled state would be better than something that moved these all to the standard copyright law, or perhaps something that was more stringent than what we're using now for most material. So we have another question period now, if anyone's thought of any more questions.
I'll give people a second to type.
Yeah.
So we do have a question here.
Yeah.
Can you talk a little more about the streaming and UCLA and what the problems were in more detail?
Well, one of the issues, and you know, I think one thing I should disclaim with is that it's sort of, to some extent, a he said, she said kind of situation, and I'm not, I don't work at UCLA. But one of the issues was whether UCLA had signed a contract that said that they would not stream. And Ambrose said that they had, and they said that they hadn't. There was also in one of the pretrial documents an interesting idea that even if they had signed something that said that they would not stream, did the fair use rights of UCLA sort of trump the contractual agreement? And I think this is a really interesting issue that's coming up a lot in all kinds of parts of the law. And when for an example, I'll tell you about a a seminar I went to recently that was about property law and contracts, not really particularly about copyright, but the person who was giving it talked a lot about how we are all the time signing away various rights we have. So for example, and this does somehow, this will loop back around to UCLA by the time I finish telling this story. So for example, we see something we're going to buy or download, and we click on a little thing that says I agree, and you know, I mean, how many of you read those terms and conditions? You know, if I did a poll right now on that, most of you would say a few of you do sometimes, but most of you probably don't. There's a lot of those kinds of agreements that we make just sort of to get through our lives, and we give away sort of things that are part of our normal rights all the time in those. So we agree that we will, if we have a dispute with, oh, you know, company that sells gold watches, that it will be arbitrated in the state of California, and you know, we're not going to go to California for arbitration. Or we agree that we'll never distribute such and such, and we haven't read those policies. And so the question is, to what degree can contract law trump everything else? The default position legally has been contract law always trumps, but I think there is more and more a sense that that isn't really working in the age we're living in now. And is it possible always to sign your fair use rights away? The orthodox position now is yes, it is. Will that always be the orthodox position? Amongst legal scholars, there's some concern that we need to move away from the contract, especially when there's really not true consent or no equality of bargaining power, where the contract doesn't always control every right you have. And that, I think, might have been an issue that would have come up in the UCLA litigation had it gone forward, but it looks now like it won't go forward. That may have been a longer answer than you wanted, but it was more detailed. Other questions related to my answer?
We have one question here regarding the Golan v. Holder case. And Corey Baker writes, we know to do the research to find out the standing of a resource with regard to copyright. If some of our material is part of these copyright restoration cases, is it our responsibility to know that? How often will it be reasonable for us to do that research for materials that we've already cleared? What will be the responsibility of the copyright owner? And will not knowing about the restoration be a reasonable defense?
Well, I think the whole issue of how much research you have to do is a thorny and not settled issue. You know, it's hard to know how much you have to do, and generally, I think you have to do a good faith effort, whatever the heck that means. If you are heavily into this area, if you have not read the work of Peter Hirtle, H-I-R-T-L-E, from Cornell, you should. You may have already. I think he talks at some length about the risk calculations that institutions need to make as they digitize, and he also has on his website and in his book about intellectual property issues for cultural institutions some really, really good flowcharts and just sort of regular charts about what's in the public domain, what might be in the public domain, and how to feel that you've done your due diligence. And of course, you know, your due diligence varies by material from material, and it also varies by you've got your risk calculation, I guess is what I'm trying to say. Sometimes one feels that you haven't been able to clear everything to the nth degree, but it is good enough, and you have a good takedown policy in place, and it is low-risk material for any number of reasons. Is that a helpful answer? It's not definitive, but this is not a definitive area at all. Hirtle also has a really excellent article on restoration, and mostly explaining why it's so very, very difficult to clear the rights in that area. But again, I think your risk calculus comes into effect too.
Okay, well, that's all the questions that we have right now.
So I'm going to talk a little bit next about Google Book Search. This is a favorite and ongoing topic for so many of us. The Google Book Search litigation, most of you probably know all or much about it. It began in 2004. Google had started digitizing books with the help of libraries and displaying them on the web. There have been many iterations of the Google Book Search over the years. For many materials at this point, they only display snippets of them. There was a class action lawsuit almost immediately led by the Authors Guild and the American Association of Publishers. There was then a settlement reached between Google and the plaintiffs, and what has been at issue for the last year or so is what's going to happen with the settlement. So I'll say just a bit about a class action lawsuit and then a bit about orphan works. A class action lawsuit is different from a regular lawsuit in that you have a bunch of plaintiffs, and some of them don't even know they're plaintiffs. In fact, most of them might not know they're plaintiffs. You've probably noticed this if you've ever gotten a notice in the mail. I got one recently that said that I was a part of a class of people who took a bar review class and could maybe get some money back. And you know, I had no beef with the bar review people, but of course I'm in the class of people who, where some of the people did have a beef with the bar review people. In most class actions, they're good for pooling resources. They're good when you've got a lot of people who may have suffered a wrong and there might be a whole bunch of lawsuits that would just drag on and on and on otherwise. There's a small dollar reward usually for every plaintiff, and everybody gets a piece of the pie. The bad side of class actions is that they're hard to manage because there's so many people, and figuring out what is a fair settlement, the legal term is fair, just, and reasonable, is really difficult sometimes when you have people who are supposed to all have kind of the same interest, but maybe they really do and maybe they don't. One of the big issues in the Google Book Search litigation has been the status of orphan works. These are works that are still in copyright, but sort of nobody cares about them anymore. The rights holder's not known. Maybe they didn't make a lot of money, or they made a lot of money at one time, but not so much anymore. Rights holders may have died. They may have left their rights to other people, but the other people may not know or care. And so one of the issues, and that was sort of implicitly alluded to when we were talking about restoration and digitization, is what if rights holders come out of the woodwork? What about then? How much liability do you have at that point? What is your risk? So in a class action, the judge decides if a settlement is just, reasonable, and fair. So one of the things that most judges are always working towards is the last thing you want when you're in court is litigation. Litigation is expensive, it's hard on everybody. It's much better if eventually the parties can figure out a solution for themselves. But when there is a class, because there are so many people involved and not all the people are at the table, the plaintiffs and defendants or defendant make a settlement, but the judge has to approve it, and the judge has to say, you know, I am speaking for all these people in the class who are not at the table, and I think this settlement is fair or it is not. What happened with the Google Book Search litigation is that the judge decided that the settlement wasn't fair, that there were too many people in the class who didn't like the settlement, and that there were some real problems with the settlement. And that happened in March. One thing that the judge didn't do when he said the settlement's not fair is that he didn't say anything one way or the other about Google's fair use claim in doing the digitization at all. That wasn't his ruling. His ruling was solely on the basis of, does the settlement that has been reached, is it going to benefit and fairly the vast numbers of plaintiffs in the class? So where in the heck is Google Book Search going to go now? Well, the alternatives for the parties are to go ahead and have a trial. They could try and revise the settlement. One of the problems with the settlement was that if you didn't want to be part of it, you had to opt out, and it could be that if they revise the settlement in a different way with regard to how the plaintiffs are handled, that it would be accepted. Another possibility is that the plaintiffs could abandon the litigation. There will be a status conference on June 1st with the parties. When you're in the process of all the things that come before litigation, there are lots and lots of conferences, again with the idea that a lot of things are better than litigation, and a settlement of some sort is better than litigation. And so these status conferences are a time when the parties get together with the judge and sort of take stock of where they are. In the wake of the rejection of the settlement, there have been a lot of discussions about, well, where should we go now that we have this corpus of books digitized, and we don't have a legal way yet to deal with that. Some legal scholars are suggesting that the government should get in the business of running a rights registry that deals with orphan works instead of having Google do it, which was sort of Google was going to have partners in that, but they weren't governmental partners. Another thought is that in the past there have been efforts to reform the library exceptions to copyright law in Section 108. These are exceptions that cover reproductions that libraries can make, and they're pretty narrow exceptions. Should those be broadened to include some of the Google Book Search type of activity for library preservation and digitization? Make showing snippets of text explicitly legal. Google Book Search has been doing, Google Books have been doing this on the basis of fair use, but should there be something that says in the copyright law, this is okay? When Google began digitizing, there was a movement in Congress to really try to deal with the orphan works problem that I described. What do we do when we don't know who the rights holder is, but there's a rights holder somewhere? What is enough when you've digitized? Where are your safe harbors if you've tried to find the rights holder and you couldn't find them? That legislation was kind of abandoned because the Google Books situation kind of took over all the airspace, as it were, around that issue. Should we try again to get something in the law that explicitly addresses that problem? And in general, should we have explicit safe harbors when entities digitize if they believe there's no concerned rights holder? What should those safe harbors be? Exactly what should your due diligence be before you could take advantage of them? Things that are vague now, and I think it would be, lots of people would love to see some more explicit answers for those things. Similarly, just recently the Library Copyright Alliance has asked for, has been calling for copyright reform. Some of the things that they're calling for are similar to what I just talked about. They are interested in situations in the law that explicitly say that when libraries digitize, there will be no statutory damages. So if a library or archives digitize, they do so in good faith, they really believe that they have done their due diligence and they turn out to be wrong, that they might be required to take work down, but they would never be having to pay costs. And also limit, more other limits on remedies when libraries and archives digitize in good faith. I think that many of us would love to see something like that. It remains to be seen whether this will go anywhere or not. But it could be that the situation with Google Book Search sort of opens the door for that. I'm going to talk briefly about Costco v. Omega. This is a case recently that went before the Supreme Court, and the Supreme Court couldn't decide. The Supreme Court split with one person abstaining, and so a lower court decision held. This has to do with whether when a copy is first purchased abroad, where is the first sale? Can the first sale be abroad? And the at the lower court, at the appeals level, the court held that the first sale doesn't apply to copies made abroad, and the Supreme Court split on their opinion about this. The case involved luxury watches that were bought overseas and then resold at the U.S. So really not a case about libraries, except it was a case about libraries in that it was about first sale. So what does this case mean for libraries? You know, we buy a lot of material overseas, we import a lot of material from overseas, and do we have a problem with first sale if we haven't, if we have done that? Most onlookers believe that there are other parts of the copyright law that we can use to continue these practices. One of them is fair use, and there are other fairly, I want to say minor statutes. They're not minor if you're in the business of import, but other statutes that allow libraries to import materials from overseas. Another issue that about first sale that is really having a big impact on libraries right now is the whole issue with ebooks. In the world of ebooks, a lot of times we don't really own the book. We have a contract involving the book, and as many of us have learned recently, our contracts can change. Sometimes, depending on the language of the contract, that can change pretty fast. A number of libraries found this out when they had purchased, you'll have to pretend you can see my air quotes, books from HarperCollins, and then they found out that they would need to repurchase licenses after they had lent the books for so many times. I think this issue is definitely going to have a large impact on library operations as we move to more and more e-material. A lot of times we have our perpetual license and it is less than a sale. Interestingly enough, I belong to the intellectual property section of the American Bar Association, and so I get their newsletter every quarter, and it's usually a lot about trademark, a lot about patents, occasionally something about copyright, but the lead story in the magazine I got yesterday was about ebooks and for sale. This is an issue that as we all start using ebooks, more and more of us are noticing, oh, wait a minute, you know, I either can't lend this ebook or I'm having, I can only lend it to certain people. It doesn't act like a hard copy book acted. The author of the article I just read said, you know, maybe we need a sort of special first sale right for ebooks that would allow copies to migrate without, but also destroy the original copy as it went, sort of a special replicate and destroy DRM. I'm still thinking about what I think about that idea, whether I think that would work or not. I wanted to mention a couple other things, not a controversy exactly. The ARL is presently investigating a code of best practices in fair use for academic and research libraries. This is a multi-year process, so sometime in 2013 we should have a sense of what they think libraries in the U.S. who are academic and research libraries believe fair use is, and this will be something that we can point to when we have difficulties or perhaps are in litigation to say, you know, we are in conformity with our peers with this issue. And the last big question that's kind of on everyone's mind in the copyright world is what happens next at the Copyright Office. One of the things that's very important in that office is who is the Register of Copyrights. Mary Beth Peters had been the Register for some time. She recently retired. In many ways, she was I think a very fair and neutral figure. Many people are angling for the job now. Some of them are explicitly allied with one camp or another in the ongoing copyright disputes. And so it will be interesting to see what happens in that world and who is the next register. So we have 4 minutes by my clock for more questions, if you have any.
Hi, this is Kristen, just checking to make sure people can hear me. Okay, so we have a question here. I heard that Costco is being followed in the Ninth Circuit Court. Is that true?
Okay, Costco went to the Supreme Court. So I guess what So I guess I don't completely understand the question. Did it come from the Ninth Circuit when it went to the Supreme Court? Is that the question?
I'll let Deirdre Clarkin, who wrote the question, if she wants to clarify, and we can come back onto that. Okay. Oh, here we are. She wants to verify if the Costco decision in the Ninth Circuit, does the lower decision stand since the Supreme Court was split?
Yes, absolutely, yeah. If the Supreme Court can't decide, then the lower court decision stands, correct. And so, of course, one issue is whether, you know, what force of law does that decision have? It has maybe more than if it hadn't gone to the Supreme Court, but less than if the Supreme Court had explicitly ruled.
Okay, and do you have any guesses on who might be taking over in the Copyright Office?
A lot of people tell me good things about Maria Palante, P-A-L-L-A-N-T-E. I don't know if she's the front runner or not, but she's certainly the person I hear and people say, gee, she would be really good.
Okay, and let's have time for one more question here regarding Kindles. If a library lends a Kindle with titles, are there copyright concerns for libraries?
What I would do is, and this has changed from time to time, look at what your terms of use say. And one of you, somebody's chime in if I'm misremembering, but at one point my understanding was that the terms of use said you could not lend, but people were doing it, and Amazon wasn't going after you that much. It wasn't going after you. I think the terms of use may have changed recently. You can tell my library doesn't lend Kindles, but I think that those terms of use are your starting point.
Okay. We have a couple more questions, but I think I'm going to wrap up. I'll just make a note of thanks for Felicity Dykus, who provided technical support and had to leave because she had a tornado warning.
Oh my goodness!
So
severe weather before we start.
So the recording is still continuing, so hopefully we won't have any problems with that. And I'd also like to thank you, Anne, for taking the time to cover these cases on intellectual property and how they relate to the libraries. It's been a great conclusion for our collection series of webinars that was held this spring. And thank you, too, to all the attendees. We hope you found today's session useful. And you'll soon receive a short online evaluation form, so please take a few minutes to respond to the questions and return the form to us. We use these comments in the ALCTS committee and try to plan additional continuing education offerings based on what you tell us. Let me grab my slides, and I'm going to put up a link here so you can see some other ALCTS events. If you go to the website there's only one more webinar this year, which is part of our institutional repository series. But we're doing more webinars coming in the summer and fall, and we're getting those scheduled right now, and they should be posted shortly. We welcome your suggestions for webinars and other continuing educational opportunities. And you can use that link that's on the screen right now to suggest a topic. And finally, before you leave, I'd like to mention that ALCTS is going to host a webinar playground in New Orleans during the ALA Annual Conference. If you're planning to attend ALA Annual and you'd like to find out some more about the nuts and bolts of developing and presenting a webinar and get some hands-on experience with GoToWebinar, which is the software that we use, you can join us on Sunday, June 26th between noon and 1:30, and we'll be sending out some additional details and location information as we get that figured out. So thank you for joining us this afternoon, and we hope that you'll participate in some other ALCTS webinars in the future. And thank you very much.
Thank you, Kristen. Thank you, and thank all of you. I appreciate the opportunity.